court is now in session. Please be seated.
All right. Thank you so much. Madam Clerk, you may call the next case.
State of Tennessee versus John David Cunningham.
Good morning again, Your Honor. Patrick Nally, National Bar on behalf of Mr. Cunningham. I would like to reserve 3 minutes for rebuttal argument, and I will try very hard to stick to that this time. It almost seems like this morning's docket seems to be lessons about preservation of issues for appeal. Because I have to admit very candidly on this one, the most important issue from my perspective as the appellate attorney for Mr. Cunningham was the failure to comply with TCA code 24-7-123 subsection 1 that requires for the admission of a forensic interview that the child must testify under oath that it is true and correct. And there's simply, that did not happen in this case. But what's worse is that trial counsel did not object during the pretrial hearing on that issue, and trial counsel did not raise a contemporaneous objection when the child testified during the trial that she lied during the course of the second forensic interview about the allegations on her father. And trial counsel did not preserve it in the motion for new trial. So I am operating under plain error review. But I am fortunate that last summer there was a case released by this court, State versus Stiegel.
Please, sir, please leave the courtroom if you can't do that right now. You're interrupting argument. No, sir, he's fine. Thank you.
And I would
I
like
apologize, Mr. McNally.
But
You may proceed.
been there, I understand. I would like to also say that I remember the expression of say what you mean and mean what you say. And I think the legislature meant what they say when they wrote that statute. And this court, as well as the Supreme Court in the McCoy case, said it means what it says. That is that you must, for the forensic interview to come in, the child must testify under oath that it was accurate or that it was true and correct. And that started with the McCoy case in 2014 by our Supreme Court. That was a fundamental requirement before a forensic interview could come in. The case I was going to get to about last summer, though, it's State versus Stiegel, and it's the citation is 2023 Westlaw 6319610.
You cited it in your brief.
It
We're
is
very
cited
well
in the
aware
brief,
of it.
but-
I think Judge Ayers wrote that.
Yes, yes. And I give the cite there because I'm telling you, I'm really relying on that because in Stiegel, this court found that the failure to comply with that first requirement that I've mentioned before was plain error. The court found that there was a violation of clear and unequivocal law, rule of law. The court found that there was a substantial right at play in it.
Well, let's talk about what Stiegel stands for.
Okay.
Because Stiegel, in that case, there was no other testimony to describe the, I don't know if it was the ag-sex bat or actual penetration of the victim, other than the forensic interview, which is what the state, I think, argues in response that distinguishes Stiegel from what we have here. So talk to me about that. Why is, I guess, Stiegel on point for this case when we have evidence independent of the forensic interview?
Well, I would first say that the evidence that was independent of it is very suspect. In fact, if you look at the record, you'll
But you agree that there is evidence independent. We have a live victim who testified as to, I apologize to the public.
I know what
Yes,
you're saying.
she testified to at least 3 or 4 instances of licking in the private area, whereas in Stiegel, the victim's testimony regarding the contact was general. We as a court were unable to find any testimony outside of the forensic interview. Here, not only do we have the victim's testimony as to those particular counts, we also have the other interview for the Our Kids medical history that came in. There are other things, so talk to me about that.
Yeah, well, I want to get back to what the court, or what the state did argue about the distinction of Stiegel, but first I'll try to address what this court has brought. Yes, in Stiegel, the court made clear that there was no other evidence other than the forensic interview that came in, and therefore it went to that prong about whether they needed to review it to do substantial justice. Here, I would also say, while maybe not as strong as in Stiegel, the evidence that was presented by the state to support these 13 different convictions is suspect, and it doesn't even match up once you take the second forensic interview out. You've got a couple. First of all,
When you say doesn't match up, what do you mean?
you don't have 13 elections of offenses. Basically.
Assuming the elections that stem from the forensic interview are out.
Correct.
Do you agree with me that the elections match up?
They do not match up to the convictions because the forensic interview is what they were relying on for many of them.
Okay.
Yeah.
Okay, hear me.
Okay.
Assume that the elections that stem from the forensic interview, because we all see that there was very little done on this forensic interview, assume that those are out. Just assume that they're out. There remain other elections and offenses that are supported by independent evidence. Would you agree with that?
Yes,
Okay.
but the evidence is suspect because when Your Honor says that there were 3 or 4, that the child testified to 3 or 4 counts of licking, she first initially said there was only 1, and then upon further questioning by the district attorney, with direct leading questioning, she moved it over to 3. She changed her story to 3 or 4, and Judge, I went through the thing. Testimony
nonetheless, and defense counsel, trial counsel did not move to strike that testimony or call for a competency hearing based on this young victim's testimony.
Correct.
You agree?
I agree. But there's questionable, at least in the record, there's questionable about 1, and then she changes it to 3 or 4. But also,
But the jury heard that, right?
The jury did
I
hear
think
that.
that's, to Judge McMullen's point, the jury heard it
Yes.
and chose to believe the victim.
And I'm not sure that they chose to believe the victim for conviction on the various different counts based upon that testimony alone. But I would also point out that there are numerous times throughout the trial where she said she did not recall the defendant touching her private in her butt with his hands.
Are you saying that the admissibility of the forensic interview prejudiced the other counts?
Yes. Because, absolutely, because if you got this very questionable testimony by the child, and there's 11 different times when she says, I wasn't telling the truth, or I don't remember that. There's a lot of things in here where she says that she doesn't remember some of the allegations that are alleged in the forensic interview. I didn't remember the defendant touching my private or my butt with his hands. When asked whether the defendant touched her private with his private, she replied no. A second time she was asked, when asked whether the defendant's private ever touched her private, she replied no. Again, a third time she was asked, the victim could not recall whether the defendant's privates had touched hers. This is all in volume number 6, pages 141 through 157.
I know you're going to get into Ruzicka.
I'm sorry?
I know you're going to get into the state citing of Ruzicka as to why that testimony still stands.
I understand, but what I'm saying is, getting back to whether this court needs to review it to do substantial justice here, I'm saying that the evidence in this case is very suspect without that second forensic interview. Let's remember, there's a first interview where the child says nothing ever happened. That's in November of 2019. Then after she's meeting with her counselor and she's being around her mother and her grandmother more, she suddenly comes out in February saying to the counselor that something did happen. And then we have this second interview. And yes, there is the medical report that came in where there was an allegation, but again, nothing of like the second interview. There's also the reports that Janie Berryman says that she's sitting outside the judge's chambers and she hears this, hears the child testify about certain acts that occurred. That's very suspect to begin with because of the way that it occurred, but the second forensic interview bolsters the credibility of the child improperly here because it should never have been admitted. That's my response.
That's your core argument.
Yes. And in Stiegel, they really do say that in consequence, we hold that the only circumstance under which a child victim's video recorded statement may be admitted in a manner consistent with both the statute and the right of confrontation is when the witness first authenticates the video recording and then appears for cross-examination to defend it. Citing back over to McCoy, which says that to get this video recording in, the child has to testify that it was accurate, that it was true and accurate. And that never happened here in this particular case. Yes, Your Honor.
I mean, this statute is still one that we're learning. It's not, at least wasn't around when I was a trial judge. But if, from a practical strategic matter or standpoint, if the defense attorney, whoever it was, had objected to preserve it for us to review, wouldn't the remedy be for the state just to put the child on and say it's true and correct?
Yes, that's right. In
So-
fact, go ahead, I'm sorry. You
Well,
first.
I guess, and my question is, what the defense attorney to do to preserve it for appellate review?
You know, the defense attorney has to make the proper objections. And that could have been made
That's true.
pre-trial, it could have been made during the, well, in fact, I think it should have been renewed, or should have been made at pre-trial, and then it should have been made during the course of the trial when the child testified numerous times that she lied during that second interview, going to the trustworthiness or not.
But she never was asked the question that B1 requires, correct?
Correct.
For that second interview. The first one apparently was stipulated that it would be admitted.
Yeah, that's really interesting because, I mean, one of the things I have to address is that it was not weighed for strategical purposes. And it's very clear when you look at the transcript of the pretrial hearing that trial counsel believed that the first interview was coming in, that it was stipulated. He actually says that it says here that I think the first interview is stipulated. It needs to come in. He says that it comes in, especially if the second interview comes in. And interesting, the state even says the first interview doesn't fall under that statute because there was no allegations of child sex abuse there. But I want to get back to one other thing that Your Honor reminded me about. There's a very interesting thing that occurs in this case between day 2 and day 3. And that's between volumes 6 and volume 7. In the latter pages of the second day of the trial, the state is getting ready. The state makes a request to recall the child back to the witness stand, and they have a hearing about that. And the judge determines that she has not been tainted, and is going to allow the state to call her back to the witness stand. And they're playing with their audio equipment. They're getting it ready and everything. And then they're having troubles. In fact, the judge kind of jokingly says, Judge Taylor says that this courtroom has ghost because the audio-visual equipment's not never seems to work. So the state's working on getting that ready. And it has every appearance that they're calling the child back to do exactly what you said. Put her on, say it's true and accurate, and play it, you know. Well, the judge finally says, okay, we don't have the equipment working. How long is this going to take? They say, well, it's going to take 40 minutes or more. And the judge says finally, okay, we're going to call it for the day. I'm going to release the jury. We'll come back tomorrow morning. Okay, day 3, they come back. The judge takes a bench and says, okay, we left off yesterday where I allowed the state to recall the child to testify. State, is that your first witness today? No. The state doesn't call her. The state calls Shanika Morgan, who is with the Child Protective Services. And they go on and never have the child testify again. Eventually, they call the person who did the forensic interview, and she testifies, and they introduce the video through that. Now, to me, that was something happened. And I can't speculate because there's nothing in the record. The judge never asked, why aren't you calling her? The state never explains why they're not calling her. There's just that sudden, abrupt change of plan. And they should have. They should have put her on there to meet the statutory requirement. Now, what I also want to point out is that the state says that Stengel is distinguishable because in our case, we have a pretrial hearing where the forensic interviewer testifies about her qualifications and about her and about what the child advocacy center is like, that the system works right, the audio and the visual is working correctly. However, in Stiegel, the case was brought back on a rehearing because the state filed a motion to reconsider and motion to supplement the record, which turned out that there was actually a hearing where in Stiegel, the forensic interviewer did testify about her qualifications and what the center, the Child Advocacy Center was like. So that is not distinguishable here in this particular
But
case.
the key in Stiegel was that there was no other proof presented at trial to substantiate the crime.
I think that was one of the factors in Stiegel, okay? To go into the plain
That was,
error.
yes,
Yeah.
a major distinction between this case, which is why I was trying to get you to tell me the distinction or tell me why Stiegel is applicable here, because we do have other independent evidence.
Well, in Stiegel, she also, the holding is very clear that the child did not testify under oath, and that's why they found plain error and remanded it back, while going through the all 5 criteria analysis.
Okay.
I don't think it doesn't rest exclusively on the fact that there was that the court found no other evidence. I do agree, the court noted in there that there was no other evidence, which went to the 5th factor as to why it was necessary to review
It
this for
says,
substantial review.
because the recording of the forensic interview was the only evidence presented at trial to show where defendant actually touched the victim to support his conviction for aggravated sexual battery, we find that a substantial right was adversely affected. That is Stiegel.
And that goes to the 5th part, either number 3 or number 5, a
Sure.
substantial right, number 3 probably, a substantial right was, substantial right was involved in the analysis of Stiegel. But it isn't the only thing that they hold in there. That's one of the factors. And what I would say here is that in this particular case, you not only, there is one thing that is distinguishable between this Stiegel and this case. Well, there's one that the honors brought up. The other one is the fact that in Stiegel, the court noted that the child testified at trial that what she said in her interview was truthful. Now, they did not ask her the appropriate questions, but she did testify that what she said in her interview, and the court in Stiegel wrote, and while the victim did testify that she told the truth at the interview, based on the record, the victim did not at any time under oath authenticate the video. Here, this child admitted during the trial that she lied. That she lied numerous times, both during the video and she continued to say, well.
The concern that I have with this victim's testimony,
Yes, Your Honor.
giving young victims leeway as we do in these types of cases, is that there was no objection to this victim's testimony. There was no motion to strike. There was no motion to revisit the competency of this victim. There was no motion by the defense to recall the victim. There was no motion to cross-examine the victim on the video. There was nothing for this court to really get into the issue that you're talking about, which is the inconsistency of the victim's testimony. That's my concern, and I think that's what I gleaned from the state's brief.
And the other concern I have too, Your Honor, is that the trial court never went into an analysis of the inconsistencies between the first interview and the second interview. The
Fair
trial
enough.
court, after hearing the child testify about lying, where she actually says, where she was asked, if you had said that his privates went in your privates in the interview, were you trying to tell the truth, or was that made up? I don't know, because in the video I did tell some things that weren't true. Like what? I don't know. Like a lot of things, mostly a lot. Over and over again, she says, when asked about it, okay, is it you're talking? Well, tell me about what were the first lies that were not true. I don't remember all of them, but I do know that most of the time they were not true. Okay, is that about when you were talking about being inappropriate? Yes. And what I'm saying is the trial court also didn't even look at the videos during the first interview, during the pretrial hearing, didn't even look at them, and only addressed 2 things of the many factors supposed to consider about the truthfulness of it. And those two things were, one, motive to fabricate, and two, the relationship between the father. That's the only thing in this very half a
I give you that. I give you the trial court
Okay.
here did an absolutely poor job.
And that's why I'm here, because.
Well, I was wanting you to address some other things in terms of the impact of the admissibility, what the forensic interview had on the other evidence in the trial. But you're out of time.
All
I
right.
appreciate you, Mr. McNally.
Okay, thank you.
Ms. Wilbur.
Good morning. May it please the court, Lacey Wilbur on behalf of the state. Your Honors, I will contain my argument to issue 1, as that is what he has addressed here in oral argument today, and I'll rely on my brief for the remaining issues unless this court has any questions for me on any of the other issues. And Your Honor, you've cut to the heart of it. There was an error. There was an error in the admission of the forensic interview. I was going to argue that he substantially complied with it, but that was not in my brief, so I shall not say that today. But what we have and what he could not prove is the other prongs of plain error. He admits he's under plain error now, and it's not his fault, it's different trial counsel. And he cannot show that a substantial right of the accused has been adversely affected, and he cannot show that consideration of plain error review is necessary to do substantial justice. The reason being on a substantial right of the accused is there was no confrontation issue here. As you noted in Stiegel, the victim gave no testimony whatsoever about anything that happened. And what we have in this case is the victim gave live testimony that the defendant put his penis on her legs. She described the coloring of some substance coming out. That is count 11. She testified that he licked it off. That is count 12. She testified that he licked her privates on 3 or 4 occasions.
How do we know that? I looked through your election of offenses. How are you drawing your election in terms of the dates with the victim's testimony on the licking? And how does our kids, the medical history that came in that basically substantiated what the victim was saying, come into play here?
On the election of offenses?
Yes.
Well, the election of offenses, the state specifically said from the video. But what I'm saying is there is corroboration and there was no confrontation problem because the victim did testify about these things for which the defendant did get convicted.
And so that's just 4 counts. He was convicted of 13. So is the state going to concede that those other?
No, what we have, though, is we have the testimony from Ms. Howlett and Nurse Luttrell, who were doing the physical examination, and that was admitted under the medical diagnosis exception to the rule against hearsay, and they testified as to what she said.
So is the state's position that that video had no impact on the jury?
I can't say that. I have no idea that that had an impact, but what I do know is she did testify on the video that about some painful penetration.
And that was inadmissible evidence.
That is admissible if the court had
No, that's
followed it.
not. This court did not go through the many factors that are required for the admissibility of that forensic interview.
I would just take a little quibble, and the court on page 17 of volume 4 says, I have considered all the factors of 24-7-123B2.
The record
But
plainly shows
specifically-
that the court did not. I mean,
He
even though
says-
he says it, he did not. It was not authenticated by the victim prior to. There was no, I don't want to get into, I don't want to waste your time on all that, but that's a losing issue.
I do want to point something out, though. The victim does not have to testify pre-trial because subsection B2 says these things must occur pre-trial. B1, the victim has to authenticate it. But I don't want to get into the weeds on what was right, what was wrong. What we have is he cannot show plain error because a substantial right of the accused has not been, he did not, like you said, he did not move to strike her testimony. He did not move to re-cross-examine her after the video was played. And this gets into Rizika, which Your Honor has mentioned earlier, and that is under plenary review. And in that case, the victim testified through a later witness, the video was played, and defense counsel did not call the victim to testify again to cross-examine her about anything. And this court said that that was there was no error there because he had the ability to cross-examine her.
I guess-
She was present, and he chose not to.
For me, Ruzicka had much stronger proof, okay? In this case, the victim's testimony here, I think, if you're being honest, was very inconsistent, okay? Now, Ruzicka, you had admissions from the defendant, I need to go to jail. You had medical testimony as far as blunt trauma to the victim's private area. I mean, that was much stronger proof to say, hey, there's no error here, in the admissibility of the forensic interview. This is not the same thing.
I understand that. And what we have, though, is we have the jury hearing all of this. This child was 6 years old when she gave her first forensic interview. And at trial testimony, she said, I lied a lot at that interview because I was uncomfortable saying this stuff to someone I didn't know. And to give specifics, they said, well, what was a lie that you said? And she said, well, when they said, is there a bad place that someone can touch you? And I said, no, that was a lie. And then later she gets a little confused, and she tells the prosecutor several times, I'm nervous, I'm really scared. She had just turned 10 years old. She was in the 3rd grade. And she said, I'm really nervous. And so she does kind of say, I lied in the videos, but on redirect examination, when this court reads the trial transcript, the prosecutor narrows it down and drills down and says, on that second video, when you're talking about the inappropriate things your father did to you, were those lies? And she said no. So she made it very clear on redirect examination that the things she testified in that video were true and not false. And again, this was a jury question on what do we accredit, what do we not accredit. But again, back up, and we're here on plain error. And again, we are arguing that they have failed to show 2 prongs of plain error review, and they are not entitled to relief. I hope I've answered your Honor's questions. If there are no further questions, we ask that you affirm.
Let me, before you leave.
You did this to me last time, too.
Did I? Did it go badly then, too?
Yes, it did.
For me or you?
For me.
He did not, you're correct, he mainly argued the issue regarding the forensic interview number 2. I had some questions, though, about the testimony, the relevancy of the testimony of the neighbor who first disclosed. Under what theory was that admissible? That particularly the emails or text messages, I believe they were, about what a bad person the defendant was.
Well, let me just say on those texts specifically about what a bad person they were, they came through defense counsel. Defense counsel asked about those specifically and read those aloud to the jury. The state just introduced them into evidence as an exhibit and did not go into them at all.
But what's the difference? I mean, if you get to introduce it as an exhibit, the jury's going to see it.
But I'm saying that defense counsel just really brought it to the forefront. Yes, it is an exhibit as in evidence, and the jury could have read it, but
And there was an objection.
There was an objection.
There was an objection, and the judge said it's relevant because they're texts. That's
and
what
that, I didn't really understand that ruling. Can you explain that?
I don't know that I can honestly explain that ruling to
Okay.
Your
It
Honors
went
either.
badly for you again.
Yeah. No,
Okay.
but honestly, I don't think that her testimony had much impact at all. And
disagree
you
with that.
can disagree with me, but she was just a neighbor, and she said, mother came to me and disclosed that her daughter was being sexually abused, and she didn't go to the police. I went to the police because I felt that was my duty, and that was the purpose of her testimony. And as your Honors, we'll get into the record, the mother and the grandmother were very not helpful. And so I think the state was trying to combat that at every corner, starting at the beginning of the trial.
A mother didn't even testify, correct?
No, sir, she did not. Okay, we ask that you affirm.
Thank you so much, Ms. Wilbur.
Thank you.
Mr. McNally?
While you're on your way, I need to correct myself. I said the statute wasn't around when I was a trial judge. I'm just now looking at it. It has been around since 2009,
Yeah.
but apparently it's been modified for several
Feel like
times.
that.
So it was around when I was a trial judge. I just don't remember ever trying a case where a forensic interview was introduced using this statute, but
It was actually modified again last year to increase the age of when it can be introduced with a child in these type of cases, up to age 18. You know, the neighbor who testified was more than just a neighbor. That was a person who actually brought this to law enforcement's attention to begin with, which law enforcement did, I think it's Detective Scott, or, you know, who then notified the Child Protective Services, who then attempted their investigation of the matter and were thwarted all the way through this thing. So this is more than just a neighbor. This is a person who actually brings it to law enforcement's attention. And to sit there and allow them to introduce text messages where she accused him of being narcissistic, a wife beater, of having an affair, you know, that's prejudicial. That's prejudicial. It's slandering him, and it's unfairly prejudicial. I should add the unfair part in there as well. There's a lot of things that are prejudicial in the case, including some of the evidence that Your Honor has brought out that are in there besides the second interview. But the second interview corroborates the other cases to other allegations to some degree. And what I'm saying here is that the trial court failed to really do the due diligence that's necessary under 24-7-123. There are so many. There are 11 ones that I printed out here that are in the red where the child says, I didn't say that in the interview, or I don't remember saying that. Did he ever make you cross your legs and get, do you remember saying that he made you cross your legs and get on top of you? No. When asked directly whether her father touched her face with his privates, the answer was no. Repeatedly in there, there's indications that the child's forensic interview is unreliable and untrustworthy. And Your Honor, going to, I think it really, as you pointed out, we're really, for plain error review, I think we've got everything in there. We've got, the record's very clear about what happened. There's a clear and unequivocal rule of law here that's been violated. The question about the substantial right of the accused, well, I think consideration of having a fair trial, of making sure that only evidence that should come in is brought in, whether it be text messages that are unfairly prejudicial, or whether it's a video interview that really lays out the state's case, because most of the case they just didn't have. So then, you know, the accused did not waive it for tactical reasons, and finally the consideration is, was this an error that requires the court to review it to do substantial justice? Mr. Cunningham says, yes, please give him another trial. Thank you.
Thank you, Mr. McNally. The case will be taken under advisement, as all of them will be, and I appreciate both counsel's briefs, very well briefed, and argument. Madam Clerk, call the next case.